And we're now live. You can go ahead.
Thank you, Stuart. Thank you to everybody that is joining in. My name is Bradley Dunn. I'm a policy manager at Sonoma, and this is going to be the informational webinar on the topic of the Sonoma County Well Ordinance update for Thursday, September 22nd. I want to invite Sylvia Lemus from our communications team to join us to share a brief message for our Spanish-speaking viewers. Sylvia?
Gracias, Bradley. Hola, soy Silvia Lemos con Comunicaciones y esta es la reunión informativa sobre la ordenanza de pozos con expertos en pozos sobre las actualizaciones y propuestas de la ordenanza. Y terminará con preguntas y respuestas de la comunidad. Si están en Zoom y quieren escuchar la presentación en español, busque y oprima el logo donde dice interpretación y seleccione el español para escucharlo en español. Para los que estén participando por Facebook, puede escuchar la recuperación en español en el canal de YouTube del Condado Sonoma. Puede encontrar el enlace en la publicación de este evento en Facebook. Muchas gracias. Brad?
Well, thank you, Sylvia. Today, we're excited to share some information with you about the proposed changes to the county's well ordinance. The well ordinance update is currently set to be the topic of a public hearing on October 4th before the Board of Supervisors. The county is updating its well ordinance in response to evolving California case law that requires local governments to protect the health of rivers and other public trust resources. To comply with the 2018 decision by the State Court of Appeals, the county will evaluate and require mitigation of the impacts of well permits on public trust resources in navigable waterways, such as the Russian River, along with the habitat and wildlife they support, including the endangered coho salmon. At the end of the presentation, we'll be taking questions from the audience. You can add your questions to the Q&A tool in Zoom or the comment section of Facebook or YouTube, where the webinar is being streamed. To go into more detail on the changes coming before the Board of Supervisors, I'm going to turn it over to Sonoma Geologist, Robert Pennington. Robert, do you want to take it away?
Yes, sorry. Thank you, Bradley, for the introduction. Thank you, everyone in attendance. I'm Robert Pennington. I'm a geologist with Sonoma. I often work on water-related projects and work closely with Sonoma Water and other partner agencies, including the groundwater sustainability agencies, on groundwater-related matters. So, as you're aware, the county is considering updates to our well ordinance to comply with obligations under the public trust. And so what that means in plain English and plain terms is that we're proposing a review process to look at potential impacts of new wells on larger rivers and streams in Sonoma County. So the requirement here stems from the public trust doctrine, which is probably not a term that everyone is familiar with. The public trust doctrine, it's within the California Constitution. It derives from English common law, and it requires or obligates that the government hold certain natural resources in trust for the benefit of the public. And those public trust purposes or those beneficial uses include commerce, recreation, fishing, wildlife habitat, and preservation of trust lands in their natural state. So what are these public trust resources? They include beaches, tidelands, but most applicable to the well ordinance, navigable waters. So navigable waters are effectively waterways that can be floated by a small boat. They've been mapped and surveyed by federal and state agencies, and we use those surveys for our ordinance. In Sonoma County, they include the Russian River from the Pacific all the way up to the county line, and then downstream portions of Petaluma River, Sonoma Creek, Gualala River, Estero Americano, and Salmon Creek. A bit of background. The last major update to Sonoma County's well ordinance was in 2015, and those changes were largely related to construction standards for the protection of public health. So protection of groundwater resources from contamination from septic systems and that sort of thing. In 2018, there was a court ruling up in Siskiyou County in Northern California along the Scott River, and it found that the public trust doctrine applies to groundwater wells. So if there is the potential that a proposed well could have an adverse impact on a navigable water, then the permitting agency has the obligation to consider those impacts and mitigate that impact where feasible. And this is an important ruling because it really recognized that groundwater systems and surface water or rivers and streams are often interconnected. And so the extraction of groundwater has the potential to reduce flows within that river or stream. In 2021, the county was sued by California Coastkeeper Alliance, and they're seeking that the county comply with obligations under the public trust when issuing well permits. So county staff have been working on this, and in August 9th of 2022, we came to the Board of Supervisors with a proposed amendment. The board did not vote on that proposal, but directed staff to make some changes, to conduct further public outreach, and to return in October. Some of the direction that the board provided was to refine the area where public trust review should be required. They also expressed interest in a priority system or some type of exemption for existing groundwater users, and then also incentives for groundwater monitoring and water conservation. So Permit Sonoma staff have been working on this and developed a new ordinance and published that revised ordinance. The update includes a screening process to determine which well permits will require this new additional public trust review. So this slide here illustrates that screening process. So first, if a well permit or proposed well is within what we refer to as the public trust review area, then that public trust review may apply. But first we look at the type of well. And so if it's a replacement domestic well, then that permit would continue to be an over-the-counter permit. We often refer to those as ministerial permits. So that's really no change in the process. If it is a groundwater well of somewhat limited use, or the parcel has limited groundwater use of less than 2 acre-feet per year, or the groundwater use is expected to stay the same or under historic groundwater use levels, then that would also be an over-the-counter permit. However, those types of permits would be subject to water conservation and monitoring requirements. And then for other wells, so wells that are generally using greater than 2 acre-feet per year for agricultural or commercial or industrial uses, that is where the public trust review would apply. So again, this only applies to this area that's referred to as the public trust review area. And we've developed a online GIS map that we encourage the public to navigate to, where you can explore the county and see what areas are included and what areas are not. Generally, the public trust review area includes areas where available information indicates the underlying aquifer is interconnected with a nearby stream that flows to a navigable water. So more specifically, in defining this public trust review area, we've included areas mapped as subterranean streams or potential stream flow depletion areas by Stetson engineers from 2008. We also include what are referred to as critical watershed areas, including Upper Markwest Creek, Upper Green Valley Creek, Mill Creek, and Dutchbill Creek. These are watersheds that are considered to be very high habitat value for coho and steelhead, and identified by the Water Board in 2015 as sensitive to reduced stream flow due to groundwater pumping. We also include what we refer to as priority basins. These are medium or high priority groundwater basins defined by the Department of Water Resources for the purposes of sustainable groundwater management. These are basins where groundwater sustainability agencies have formed and adopted groundwater sustainability plans. So if a permit is within this public trust review area, there are still options to process that permit over the counter. So there would be no additional studies required for these permits. And so these over-the-counter pathways or ministerial permit pathways include replacement domestic wells, where the groundwater use of the parcel is less than 2 acre-feet per year. A little aside there, 2 acre-feet per year, that's a relatively large amount of water use for a rural single-family residence. The average single-family residence in a rural setting is estimated to use about 1/2 acre-foot per year. And an acre of vineyard is estimated on average to use about 0.6 acre-feet per year for irrigation. So 2 acre-feet per year is roughly equivalent to 4 single-family homes. So wells on low water use parcels, so parcels that use less than 2 acre-feet per year, would also be an over-the-counter permit. However, they would be subject to water conservation and monitoring requirements. Wells for existing land use, so this is possibly an existing vineyard or an existing industrial use that's using greater than 2 acre-feet per year. If the groundwater use of that parcel is limited to the existing use or historic use of that parcel, then that would also be an over-the-counter permit. But again, they would be subject to these water conservation and monitoring requirements. In addition, we exempt public water wells. So this would generally be wells for, say, a city, as long as that permit process has gone through environmental review through the California Environmental Quality Act. So a reminder here that the two in the middle there, wells on low water use parcels and wells for existing land uses are subject to water conservation and monitoring requirements. So our list of water conservation requirements includes that all shower heads and toilets will have to meet water efficiency standards. Existing and future landscaped areas have to meet water efficient landscape regulations. There's a prohibition on all non-functional or ornamental turf. So that means, irrigated lawn areas that are not used for, play or picnics, but are just there for decoration. There's also a requirement for water conservation plans for commercial, industrial, and institutional project sites. And then there's limits on vineyard and orchard irrigation. So for vineyards and orchards within critical watershed areas, the limit is set at 0.4 acre-feet per year. For vineyards and orchards within priority basins, the limit is set at 0.6 acre-feet per year. And they would also be subject to any water conservation requirements that have been adopted by a groundwater sustainability agency. And then for all other areas that are within this public trust review area, vineyards and orchards would be limited to 0.6 acre-feet per year, or another use rate supported by site-specific data or a site-specific study. As a reminder, this would only be in association with a new water well permit at these sites. For permit applications that require monitoring, there would be a requirement for meters to be put on wells with monthly readings of the value read by that meter and also annual reporting. However, domestic properties with less than 2 acre-feet per year would not be subject to any metering requirements. And as a reminder, this would not apply at all to any existing wells. This would only apply to sites where new water wells are being permitted. Okay, so back to this flow chart. As a reminder where we are, we've just gone through the screening criteria to determine which wells are subject to the orange or the public trust review box. So everything we've covered so far is an over-the-counter permit. If you don't fit in any of those categories, then the permit is subject to this discretionary public trust review. So the discretionary review means that there are not set standards for review, and the review process and requirements and approval will be determined on a case-by-case basis. And so what this requires of the county is that the county shall not issue a well permit without first considering the impacts to public trust resources of that proposed well. That well application would be required to include information necessary to assess those impacts. So that could include hydrogeologic reports or additional information considered necessary to evaluate how that well would contribute to impacts to navigable waters. Before issuing or denying a well permit, the county would produce written findings documenting the potential impact. And then the county determination or the determination by permit Sonoma could be appealed to the Board of Supervisors. And the board could approve a well that may have impacts with overriding considerations of public benefit. To cover the cost for this review, we are proposing an at-cost fee. So currently, the ministerial permit or the over-the-counter permit is a flat fee. That would not change. So any permit that's still subject to the over-the-counter permit would still be charged a flat fee. So the permits that are subject to the public trust review, however, would be expected or required to pay this at-cost fee, which would have a minimum deposit of $1,392, which is equivalent to 8 hours of review time by a geologist or engineer. Any remaining balance could be returned to the applicant. So the ordinance timeline, we are conducting public outreach now. We expect to publish the revised ordinance and all the supporting materials for the board on September 28th. And then we will be going to the board for hearing on October 4th. So that concludes my presentation. Thank you for listening, and we look forward to hearing your questions and comments.
Thank you, Robert. Now we're going to take questions from you, the public. If you have a question and would like to share it, please put it in the comments area of Facebook or YouTube where you are watching, and we'll see it there, and it will be sent to me. Or you can put your question into the Q&A section of the Zoom webinar, which should be at the bottom of your screen. You can also email questions to permitsonoma-wells-public input, which is all of one word, at sonoma-county.org. So we're going to start with a question for which is, how do I know if I'm using more than 2 acre-feet per year?
You want me to take that one, Nathan?
Sure.
Okay. Yeah, we provide guidelines for estimating water use, and we have a policy and procedure on water supply and use estimates. And so for different types of land uses, there are various default use rates. So a single family residence uses about half an acre foot of water per year, for example. And then if you wanted to get more specific, there are more detailed methods certainly to estimate your water use, or you could use a meter to measure it.
Great. Well, I've got two questions from two different folks, one on Facebook and one here in the chat. I have an existing well on my residential parcel. What happens if I need to replace it? Two questions very similar to that. I have an existing well. I need a replacement. What needs to happen?
So you'd come in for a permit to construct a replacement well, and depending on the type of land use would dictate if you go the ministerial or over the counter process, or if you would fall into the public trust discretionary review path.
Yeah, and can you talk a little bit more about the difference between those two paths?
Sure. So if you're strictly a domestic user for a residential setting, that would be the over-the-counter ministerial pathway. If you are a low volume user, you may be subject to monitoring if it's a new well. But if it's for, Robert, help me out, but if it's for a agricultural use, you still can go ministerial if you're not exceeding your pre-existing use. But I believe monitoring would apply.
Yeah, that's all correct. But yeah, if it is a residential use, a replacement well for residential use, then there's really no change in the permitting process being proposed at all. That would be over-the-counter ministerial permit without metering or any requirements.
So I got a question, several questions about the fee structures. So what is the flat fee for administrative review?
Do they mean a ministerial review?
Yeah, I think there's this question, and then a question about do the fees include the cost of metering? So if we could just talk about the fees in general.
So on the ministerial side, before this ordinance goes into effect, we have our standard plan review fees and our inspection fees. They're roughly $600 to $700 each. So $600 or $700 for the plan review side, $600 or $700 for the inspection side. That is not changing. What's changing is for the wells that are subject to the public trust evaluation, that's an additional review, and that's where we're predicting 8 hours of time, which is the $1,300 plus fee. And if it doesn't take 8 hours, then we refund the balance. So that's our scheme for permit fees.
And then for the groundwater monitoring piece, we don't have a proposed fee, though we expect at some point in the future, we may need to develop a fee to cover the costs of that program.
So we've gotten a fair number of questions about monitoring. So we'd like to kind of delve into that. So who will be responsible for reading the meters? Is that well owners? Is that others? Is that Permit Sonoma? And how are we going to be providing forms for the well monitoring?
So the vision on that one is that would be the responsibility of the landowner. And yes, we are anticipating some online forms so that folks can just go online and input the data.
Great. And so another question was asked, which is about monitoring. If we aren't monitoring all wells, how will we know if conservation measures are being complied with?
Well, most of the commercial, industrial, and agricultural wells requiring a new permit would be subject to the metering. So for those, we could look at those water use and make sure that it is consistent with the permit application and the requirements that are placed on it. The additional water conservation requirements that would possibly be placed on new residential development. Most of those requirements are really just one-time implementation. So replacing your shower heads or, building your landscape to code and that sort of thing. So we don't anticipate needing ongoing monitoring to really, enforce those water conservation requirements.
So the next question is, are there established thresholds for the public trust determination? What would cause or exacerbate an adverse impact?
That's an excellent question. This is a new process, so we haven't defined what those thresholds are at this point, and we're working on that. We expect to use, for example, within the Groundwater Sustainability Agency's jurisdiction, within the priority basins, we expect to use the thresholds for sustainability that they've defined. And then similar along the Russian River, we'd expect to use the minimum in-stream flows that have been defined for the Russian River. So we will be relying on any adopted flow conditions, and then when a new well would cause flow conditions to be less than what have been set, then that is likely to be considered an adverse impact.
Awesome. Thank you so much for that. Will discretionary reviews be subject to CEQA? And that's the California Environmental Quality Act, for those who are not hip with the bureaucratic acronym.
I'll take that one, Bradley. The answer is yes, discretionary permits are subject to CEQA. However, each individual project would be looked at to see if it fell into an exemption from completing further environmental review under CEQA.
This one I think is probably an easy one. Does the county pay for my well repair now that I pay for fees? Or do they pay fees?
No.
Great. So the next one I've got is a little bit of a long one. In this updated well ordinance, will all fish and wildlife habitats that are listed or species of concern be protected, or only those that inhabit navigable waters? Coho salmon and steelhead trout spawn and rear in tributaries throughout the watersheds. Terrestrial species, including amphibians and reptiles, depend on seeps and springs that may be depleted from excessive groundwater extraction. The 2020 general plan includes elements to protect all species, special status species.
Jennifer, would you like to take this one?
The focus of this ordinance update is complying with the county's public trust duty. So to the extent there's overlap with protection of those species, then of course the areas in the public trust where that duty applies would help those species. But if we're not talking about a navigable waterway, if we're not in a public trust resource, then we would have no way of reaching that issue with this type of permit.
Can you please describe an example of a scenario where a well permit might be denied?
Yeah, I can.
Do you want to try that?
Sure. Well, I mean, if it's in the public trust area, we needed to go through the evaluation, and if the impact cannot be mitigated sufficiently, then we would be obligated to deny that well permit.
We've got a question that asks us to discuss the estimated timeline for permits.
So for well permits, we're currently within days of receiving the application. I mean, there are exceptions and there's some that get hung up, but generally we're within 5 to 10 days of issuing a well permit. That was before the governor's executive order for the drought. So that does create another review level, but that's not what this meeting is about. And so if there is a well that is subject to the public trust evaluation, obviously that timeline is going to increase because there's additional evaluation and additional information that's required from the applicant. So we will not be able to hold to the 5 days or 10 days for a well applications that's subject to this new ordinance.
Awesome. So we got a question to ask. How is pre-existing use determined?
So pre-existing use would be determined on a 3 to 5 year average before this ordinance is adopted. That would be considered, I guess, existing or baseline use for that parcel. And generally, that would be estimated based off the land use, unless there is better information that we can use that's available.
What would be possible penalties for a well owner subject to public trust review if it fell out of compliance?
So I'm trying to think of the scenario. So hypothetically, let's say there's a well that's subject to public trust review and that they are in the monitoring program. And we get the information that they're exceeding the allotted flow rate, for example. That would be one case for enforcement, right? So I would imagine the first layer is to inform the client that they are exceeding their groundwater extraction rates and that they need to bring that back down to within the permitted amount. And if there's a second violation, then we, would, have to take further steps up to, the final step would be leading to requiring that the well be decommissioned. I'm sure there are due process steps involved, notice of violation, notice and order, going to a hearing, getting an order from the hearing officer, that type of process before we took that last step of decommissioning the well.
And I would just note that the procedures in the current ordinance regarding enforcement of well permits is not changing.
Great. We got a question. Have engineers been consulted as to what they would need to provide for your review? If not, then I would assume that you are going to reach out to local geologists and hydrologists and consult with them regarding a course of action that they will need to take to provide you what you need. We need a clear path to move forward prior to this going into effect. Do you guys have any thoughts on that?
I would certainly agree with that statement. One of the first things that we've already started is really developing a guidance document that would aid consultants in developing a report that would meet our requirements. That said, this is new, so we are developing, are still discussing what would be required. Generally, the scope of these investigations is relatively large at a watershed scale, so it's most appropriate to use a model that's at a watershed scale to evaluate those impacts and to use existing studies that have evaluated those impacts. So for many watersheds, such as the Groundwater Sustainability Agency basins or the priority basins, those models have been developed and that analysis has been completed. Similar analyses have been completed for the critical watershed areas and other areas of the county. And at the moment, the USGS is actually completing a model of the entire Russian River. So there's a lot of information out there to draw upon. There's a lot of published reports to draw upon. And our preference is that these published materials be used and referenced as opposed to site-specific analysis. But certainly site-specific analysis will be valuable in certain cases in evaluating if a well is actually interconnected with surface water or not.
So I've got Salmon Creek Watershed was not mentioned. Is it involved? There's a direct outlet to the ocean with fish coming in.
Yeah, that must have been a mistake. The outlet of Salmon Creek, there is a small navigable portion of that waterway, so that would be included.
And then I've got what professional licenses are needed to submit a full review? And what PRMD division, which is another name for Permit Sonoma, will be doing the report reviews?
So we're looking for professional geologists with background in hydrogeology, and we're also looking at civil engineers with a similar background. And so what division or what section? So you're looking at them. It's Robert Pennington.
Yes, it's likely to be the Natural Resources Division that's evaluating these permits. So it would be me looking at the hydrogeology, and then we have biologists on staff that would be considering impacts to habitat.
Will septic numbers be used for determining pre-existing use?
Septic numbers as in like the size of a septic system?
I don't know. Richard Graham, if you would like to submit with a little bit more specificity, we will add that to our queue.
Well, can you repeat the question for me real quick?
Yeah, will septic use numbers be used in determining pre-existing use?
I don't think so, because there's water use outside of a residence, for example. So we size septic systems based on the number of bedrooms in the dwelling, but there's landscaping, water use, and other uses outside of a residence for human consumption, for example. So I would say no.
Nathan, would you say it's a factor, but not the only determinative factor?
Yes, I mean, human consumption of water is part of the consumption, yes. But we wouldn't link it to the size of a septic system, for example.
What does the requirement mean to install meters on all service connections served by a shared well?
Yeah, so that's a fairly uncommon situation, but it's when there's one well that's serving typically multiple parcels. And then each parcel could be considered a separate service connection. And we've gotten feedback from folks where this is the setup, and it's difficult to know who is using more water off of that well, and simply adding meters to those connections would serve to allow people to track their water use, and then would further water conservation, at least from that well.
Has staff considered an effort to utilize existing hydrologic models of the priority basins and/or critical watersheds to evaluate likely thresholds of well water use on surface flows in the affected public trust waters? This might help establish alternative thresholds for ministerial permits.
Could you read the start of that question one more time?
Sure, I'm sorry. Has staff considered an effort to utilize existing hydrologic models of the priority basins and/or critical watershed to evaluate likely thresholds of well water use on surface flows in the affected public trust waters? This might help establish alternative thresholds for ministerial permits.
Right. Yeah. That's a great question. We are certainly discussed using the existing models for those critical watershed areas and those priority basins. And we'll actually be looking for direction from the board on kind of a longer term policy development that would be, I guess you could say, a model driven or science-based approach where we use those models and determine, kind of conditions or thresholds of use or conditions of water conservation or limits on water use that are, I guess, needed to protect public trust resources. So that's a great idea, and what we're looking for direction from the board on our long-term policy development.
Great. I've got a question here. Are there standards for the quote unquote maximum extent feasible use reductions referenced in section 25B-13F?
Oh, Robert, I'm going to defer to you on that one.
I don't have that document open at the very moment. Let me open it up.
Anonymous attendee, if you could send an email to us, that would be really useful. It's permit Sonoma -wells -public input, all one word, at sonoma-county.org, and we'll make sure that we look up that section and get back to you on that. So I've got a question here. I'm with meter.me, and we develop a technology for metering wells. Where or how can we find out what format will the annual reporting need to be in? Specifically, would the county be interested in total gallons or also depth to water or water level reports?
Yeah, so we are requiring only water use metering. We're not requiring depth to water monitoring. The format, I mean, we're proposing to have an online interface for data entry, and it's effectively just the reading from the meter, which would be in units of gallons, but a totalized meter. So it just like an odometer just would continue to go up over time.
Okay, so we've got another question from anonymous attendee. Robert mentioned the 0.4 and 0.6 acre feet limit. He indicated that it was 0.6 acre feet, but the slide said, sorry, 0.6. There are acronyms here. Let me start over. Robert mentioned the 0.4 and 0.6 ACF limits. He indicated that it was 0.6 AFY, but the slide said 0.6 AFR per year per acre. Which is it? And if it is 0.6 AFY per acre, how do you define the acres covered?
So it is AFY, and that's an acronym for acre feet per year. And it would be defined based off the numbers of crop acreage, not the parcel acreage.
Anonymous attendee asked, who
Bradley,
will... Oh, sorry.
the prior question that was asked about the subsection F for the maximum extent feasible, I just took a look at that, and it just so we can answer that and not have to have the person email.
Mm-hmm.
The whole requirement is, and this is part of best practices that would be required, all commercial, industrial, and institutional sites shall submit a water conservation plan that details best management practices to reduce potable water use to the maximum extent feasible. So it would be up to the plan to detail what the best management practices are, and that and explain how it's being employed to the maximum extent feasible. And the guidance documents that Permit Sonoma is working on can help fill out that requirement, but we don't have it filled out right now.
Great. Nolan Irwin asked, what impact do you foresee these new outlined rules and eminent domain and riparian rights These are gray area in between, I would assume.
Can you repeat that?
Yeah, so I think it's, what impact would you foresee these new outlined rules? And it says, and eminent domain and riparian rights. I would assume it's on eminent domain and riparian rights. These are gray areas in between, I assume, is the question. Nolan, if that's not the correct way I phrased that, go ahead and resubmit your question.
I don't think we can answer that.
Okay.
Well,
Nolan, sorry. Nolan, if you want to resubmit, we will we'll make sure to prioritize your question. Judith Olney asked, so there are 4 days from this public hearing until the ordinance documents are released, and then only 4 days for review prior to the Board of Supervisors hearing / vote, fewer than 10 days. Does this meet legal requirements, or are we not anticipating a Board of Supervisors vote on October 4th? I assume that's for Jennifer.
I think that what's coming on October 4th is another first read of the ordinance. So there was a prior first read of the original ordinance. The board directed changes. That's what staff, and also public outreach. So we're working on that public outreach. We're working on bringing forward a revised ordinance that incorporates changes that are responsive to the public input and board input. And that will be coming back on October 4th for a first read. Then no sooner than 5 days after that, should the board direct that it come back, it would come back for approval. If it's approved at the next meeting, which I actually believe is at least 2 weeks or maybe even 3 weeks from October 4th, if it's approved at that next meeting on the second read, then it would go into effect 30 days later. So first meeting, first read, second meeting, approved at the second meeting, and then effective 30 days later.
So the next question we have is from an anonymous attendee. Who will supply the monitoring hardware? Will there be a required monitoring system? For some, this could be a financial burden. And then secondly, will there be fines for water overuse?
So on the first one, I believe the hardware is the totalizing flow meter that would be installed at the wellhead or close to it. And then regarding fines, we haven't gotten that far to really consider the enforcement. But as I mentioned earlier, if there's an exceedance, we would likely start with a warning or notice of violation and have to go through our progressive enforcement protocol.
Okay, I got a question. In reviewing, this is from Don Monk. In reviewing an ag property for purchase, water availability is usually a part of the due diligence review. If the property of interest does not have an ag well, sometimes the interested purchaser would want to drill a well or two to determine if ample water was available for their desired project. What would be the process and timeline for getting a well permit to complete one's due diligence review prior to purchasing the property? How long would one need to be in escrow to find water before closing on the purchase?
Okay, so thinking through that process, I mean, that's one of the first things you need to look for when you're developing a piece of property. You know, it's water, wastewater access. That's what we tell all of our clients. So those are the three main things you need. And then you can start with a building permit or building and that. But so the first one, water, you would come in, you'd apply for a well application. Part of that well application is asking what is the intended land use. And then knowing the intended land use, we would walk you through that flow chart that Robert had up earlier. You know, is it residential? Is it ag? You know, what type of land use? And that would dictate which, if you stay in the ministerial pathway or if you're subject to the public trust discretionary review.
Great. And then we've got a question for discretionary permitting that may be subject to CEQA. Will the county be required to conduct cumulative impact analysis? And that's from Gail Seymour. I'm sorry.
Again, CEQA is going to apply to any discretionary permit. The level of CEQA review would happen on a case-by-case basis. We'd have to look at the whole project. So I can't answer that right now.
So we've got a next question, which is, has Sonoma County permit, well, I assume that's permit Sonoma, studied the historic higher extraction of water from watersheds due to the increased number of vineyards?
Yeah, there's been a few comprehensive studies that the county has financed or contracted to be completed. And then other studies that the county was not, directly involved in, that have looked at impacts of groundwater extraction on stream flow. But in terms of a county-wide assessment, that has not been completed.
So we got a question that I can answer. So can you please share how we can read the draft language? So you can go to permitsonoma.org and there is an About Us menu item. And if you click that, there will be a Items of Significant Interest menu item, and that will have all of the documents for this amendment updated amendment, sorry. So the next question we have is from an anonymous attendee. Can you describe some examples of mitigating measures a homeowner can take if their parcel is in a public trust area?
Well, first off, if it's a single family residence in a public trust review area, it's unlikely to have any public trust review unless the groundwater use is greater than 2 acre-feet per year. So it may not apply, but more generally in terms of mitigation measures, most mitigation measures would involve additional water conservation, or potentially, use of recycled water or gray water, or enhancing groundwater recharge. So by building infiltration basins and things of that nature that enhance the amount of surface water or rainwater that makes it into the ground. So those are typical mitigating measures.
I got a question here. Municipal wells are exempt from the process while they are the most intensive uses of groundwater. As they continue to allow the construction of more and more subdivisions, how are they being controlled in their water use?
The Board of Supervisors directed that be one of the exclusions, and the thought being that on balance, the public interest in having drinking water for people who are living in our community outweighed the public trust factors. So that was a decision that they will be asked to make on that type of an exemption. Depending on the size, the nature of other permits that would be needed for a subdivision, there could be different angles at looking at water use, but it wouldn't happen at the well permit level for that type of a well.
The other layer to that is many of the municipal wells are sponsored by cities and other jurisdictions, and they've gone through their evaluation process as well.
Thank
Great.
you, Nathan.
An anonymous attendee asked, does a replacement well mean that the old well must be destroyed?
Yes. I think we put a timeline of 60 days. Is that correct, Robert?
I believe it's 90, but yes,
90 days.
Must be destroyed.
So I got another question here from another anonymous attendee. So different thresholds for different areas in the county, question mark. i.e. along mainstream versus in priority basins? Another question mark. Not sure I understood Robert correctly. So Robert, could you clarify the different thresholds for different areas of the county?
Right, so I guess this applies to the water conservation requirement that limits vineyard and orchard irrigation. So within those critical watershed areas, so Upper Mark-West Creek, Upper Green Valley Creek, Dutchville Creek, and Mill Creek, we have proposed a 0.4 acre feet per year maximum water use. And that's actually reflects the average irrigation use in those watersheds as reported to the Water Board. And it also reflects the sensitive nature of those watersheds in terms of fisheries habitat. And then everywhere else in the county, we're using the 0.6 or propose a 0.6 acre feet per year threshold. And that is considered the average irrigation water use by vineyards in the county. That number has been vetted through the advisory committees for the groundwater sustainability agencies. And so that's where that value comes from.
Great. I've got another anonymous attendee. My son is planning on installing a well at his property that will supply him and his neighbor who share water rights. Will the fees be split between them?
The permitting fees, I think that would be up to the two parties, how they want to arrange the payment of the fees.
Okay. Werner Siegert wrote, will old 30-year-old wells become subject to monitoring when used for domestic and vineyard use?
No, I don't.
Doesn't apply. Oh, sorry. The ordinance
that's
doesn't
right.
apply to any existing well. It's only
Yeah.
if you're coming in for a permit that we would look at the ordinance.
So I got a question from Judith Olney. Need more info on due diligence test wells. This happens before the buyer agrees to purchase the property. Will this be ministerial, as discretionary may not fit into the timeline for real estate transactions?
I think we'll need to look at that because I think the issue is what is the project? And if the purpose of the well is simply testing whether there is enough water to have a permanent well, maybe there's a way that we can create a temporary well that would not be used. It's only done to test the well, and maybe that could be done, none of this is necessarily in the ordinance at this point, but maybe this is something that we can look at. That if the scope of the project is a temporary well that's not going to come online unless the property is sold and the project is pursued, then having that longer term permanent well would be sort of a second step in a separate permit. And maybe that's where your public trust review comes in, but not at the test well stage. We can look at that if there's a need to differentiate if it's speculative and the property hasn't sold yet. But if it's not speculative and the property will sell and that will be the use, then that would be the full project we would look at for permitting and CEQA purposes.
So we've gotten a couple of questions about getting copies of the presentation. We will post a copy of the presentation and the recording of the webinar. You can navigate to that. You will be able to navigate to that probably tomorrow, by the end of the day tomorrow, from the Permit Sonoma website. There will be a button that says Well Ordinance webinar, and you can follow that to the recording and the presentation. So I've got another question here that says, I'm in the public trust review area, but not a critical watershed area or priority groundwater basin. I want to drill a well on an empty parcel with no well currently, no residents, and about 4 acres of vineyard, currently irrigated by a well on another parcel. What will this ordinance require of me to drill the new well?
So is the question, will this ordinance require a new well?
No, I think the question is they've got a parcel that is for a vineyard. It's 4 acres,
Right.
and it's irrigated by a well on another parcel. They
Sure.
want to drill a well on the parcel,
Mhm.
and they want to know, since they're in the public trust review area, what would be required.
Okay, so Robert, help me out here, but what I'm hearing is there's a new well for agricultural use. 4 acres at 0.6 per acre would put them over the 2-acre limit, which I don't think applies anyway, since it's a new well for agriculture. So that well application would be subject to the public trust evaluation, and it would go through the discretionary review process.
And I think as part of that hypothetical, we're presuming the other well is not being destroyed, that it's continuing on and serving parcel that it's on.
Mhm.
Yeah, I believe that's how I understand it as well.
And yeah. Well, I would just like to notice the time and let everybody know that it is a little bit after 5 o'clock. We're going to stay for a couple more minutes to answer more questions. But we wanted to thank everyone that has taken the time out to attend, and let folks know that October 4th is going to be the date that this well ordinance update will go to the Board of Supervisors. You can join there either online or in person at the board chambers. More information on the meeting will be available at sonomacounty.ca.gov as the agenda is posted at least 3 days in advance of the meeting. And so we're gonna try to finish a couple more questions. We don't have that many left. So we've got a question that is, what about additional, from Austin Campbell, what about additional wells needed to support existing use?
So that would fall under, we had a category where if a new well is being proposed, but it didn't exceed the existing well usage or total water usage for that parcel, then I believe it would be ministerial, but subject to monitoring.
Great. And then will this new, this is another anonymous attendee, will this new ordinance apply to proposed wells for which permits are already issued but not drilled yet before the effective date?
No, if they're issued, they're issued. And I believe we also have a pipeline provision so that if they apply, I have to think about how we got that set up, but I think it's if they apply and it's a complete application before the date of this ordinance, then they're not subject to the new ordinance.
Why don't I'll rephrase that. If an application for a well is submitted before the 10th of October, the day the board is looking at considering the revised ordinance, that it would be subject to processing and approval under the current code prior to any changes going into effect.
Yeah, and certainly for anything that's issued, they're not subject to this ordinance.
I think they're talking about other, like a use permit or something that's issued that just requires
gotcha.
a well permit later. So I just wanted to clarify the difference, that if it's an approved use permit, but the well permit application comes later, that the later well permit, it would depend when it's filed and when it's decided on whether the old or new code would apply, Chapter 25B.
And then we got a question from, I believe it's pronounced Yale or Yale Bernier. How do hotels, tasting rooms, and other visitor serving uses factor into this new ordinance?
This ordinance is focused just on wells. So to the extent there's a new well for an existing use, we would look at that. If it's a whole new development that's going through the use permit process, then there would probably already be a level of analysis of water use happening as part of that process. And the well permit would just be secondary.
And we've got 4 more questions and then we're finished up. So want to ask from Austin Campbell, following up on a timing question regarding timing. Once a well permit is applied for, assuming that it is more than 2 acre-feet per year use and in a public trust watershed based on your maps, let's assume we turn in the permanent application along with the geo or hydro study. What do you expect the county to review time to be currently?
We have very little experience with reviewing the public trust evaluations. We do have experience reviewing hydrogeology reports as part of the discretionary process. So we do have some background in this. And we've estimated an 8-hour review time. So I'd hate to commit to a processing time at the moment with such little experience on these. As I mentioned earlier, if it's ministerial, we're getting to those in a matter of days. This certainly will add time to it, and we'll, do our best to process them, but I can't guarantee a processing time at the moment with so little experience with these.
Nathan, do you want to mention the interplay with the governor's executive order and how that's impacting current permit processing times? Or that it is for some? Which is
Well,
unrelated to the well ordinance that's going on now, but just a factor that's current that may be affecting current processing timelines for affected permits.
Yeah, so I didn't anticipate that question. I haven't researched the processing times for those
Sorry.
through the executive order. But I do know that most of the wells coming in relative to the executive order are exempt. They're permit exempt because we deal with the vast majority of our wells are for residential purposes. So that was one key exemption from the executive order. But sorry, no, I'm not, I don't have that information in front of me.
And then we've got 2 last comments. Well, one is a comment, one is a question. Gail Seymour said, "A request, please consider protecting all public trust resources, whether connected or not connected to navigable waters. See case law, the Center of Biological Diversity, BFPL Group, 2008. The court recognized that birds are protected by the public trust doctrine, even if they are not specifically associated with public trust waters." And then the last question we've got is from anonymous attendee, which is, there doesn't seem to be any consideration for cumulative impacts in the current draft. Will those be a part of the overall impact analysis? For example, will applicants need to identify the number of wells on a property in addition to staff looking at other known wells in the area before a full determination can be made?
You want me to do that one? Yeah, so we would be considering, the cumulative impacts of groundwater extraction from the parcel and within the watershed, and in evaluating those impacts on those navigable waters.
We had a question about reservoirs, but since we're focused on wells, we'll skip that question. And so that is the totality of the questions that have been asked. So I would just like to thank everyone who has joined us, especially those who stuck with us to the end. I'd like to thank all of our panelists for joining today. And I'd especially like to thank the crew that helped put together the translation. Both Julie, our Spanish interpreter, and Odie, our ASL interpreter. A recording of this webinar will be made available to view on Facebook and on YouTube. If you have any questions or wish to make a comment about the proposed changes, you can email permit Sonoma, all one word, -wells, -public input, again, all one word, at sonoma-county.org, or visit permitsonoma.org for more information. Specifically, you can look under items of significant interest or search well ordinance update to find the well ordinance documents. And don't forget that we are excited to have everyone participate at the Board of Supervisors well ordinance public hearing on October 4th. You can join that either online or in person in the board chambers. More information on how to join or the address will be available at sonomacounty.ca.gov. And the agenda is posted as the agenda is posted. Thank you, everyone, and have a great rest of your evening. And we hope to see you October 4th.
Have a good evening, everybody.